In 1832, the Supreme Court of the United States ruled clearly and without ambiguity. The Cherokee Nation was sovereign. The state of Georgia had no legal authority over Cherokee lands. The law was on the side of the Cherokee people. The Cherokee Nation had not waited for the United States to recognize their sovereignty in order to exercise it. They had governed themselves across millions of acres of southeastern land for centuries, and by 1832 had formalized that governance into a constitutional republic. They had a written constitution, a bicameral legislature, a judicial system, a free press, the Cherokee Phoenix, the first indigenous-language newspaper in North America, 2 governments, 2 legal systems, 1 ruling that should have settled the question of which one held authority over Cherokee land. This is not a story about a nation that lacked legal recognition. It is a story about what happens when legal recognition is granted and then deliberately set aside. These are not just different legal arguments, they are different understandings of what the law is actually for and who it was built to protect. The conventional telling places Indian removal inside a larger story of westward expansion, something that happened, regrettable perhaps, but part of the inevitable march of American progress. The Trail of Tears appears in textbooks as a tragedy, rarely as a crime, and almost never as what it also was, a direct violation of a Supreme Court ruling that the executive branch chose openly to ignore. President Andrew Jackson signed the Indian Removal Act in 1830. When the Supreme Court ruled against Georgia 2 years later, Jackson's reported response was unambiguous in its implication. The ruling would not be enforced. The removal would proceed. From inside the dominant narrative, removal feels like gravity, the inevitable consequence of 2 civilizations occupying the same space. What that narrative requires you not to ask is, who decided which civilization had to move? The internal logic of removal rested on a particular definition of civilization, one that conveniently excluded the constitutional republic that the Cherokee had already built in plain sight on their own land. The Cherokee Nation's sovereignty did not begin with their 1827 Constitution. It was the formalization of a political reality that had existed for centuries, governance through clan law, council deliberation, and a sophisticated system of relationships between towns and regions. Traditional Cherokee governance operated through 7 clans and a network of town councils, a system in which political authority was distributed, deliberative, and accountable. War decisions and peace decisions were separated institutionally. Balance was a structural principle, not an aspiration. Sequoyah, a Cherokee citizen who had never learned to read English, developed a writing system for the Cherokee language between 1809 and 1821. Within years of its introduction, the majority of Cherokee people were literate in their own language. The Cherokee Phoenix published news, legal proceedings, and political debate in both Cherokee and English. This was not adaptation, it was assertion, a sovereign nation communicating on its own terms, making itself legible to its neighbors without surrendering its identity to them. The Cherokee Nation's 1827 Constitution established a 3-branch government, defined citizenship, and articulated the nation's rights to its territory. It was a deliberate act of political communication. Here is our government, it said. Recognize it or explain why you will not. Principal Chief John Ross led the Cherokee Nation's resistance to removal through every legal and political channel available: petitions, legal challenges, direct appeals to Congress. He never stopped arguing that the law was on their side. He was right. It did not matter. The Cherokee Nation was not a people waiting to be civilized. They were a civilization already, one that had chosen, deliberately and strategically, to engage the United States on its own legal terms. And the United States had no good answer for what they had built. Georgia's response to Cherokee sovereignty was legislative. The state passed a law requiring all white men living in Cherokee territory to obtain a state license, designed to remove federal missionaries and outside influence from the nation, and to assert Georgia's jurisdiction over land the Supreme Court would later confirm it had no authority to govern. Samuel Worcester, a missionary living in Cherokee territory, refused to obtain Georgia's license. He was arrested, tried, and sentenced to 4 years of hard labor. He sued. His case reached the Supreme Court. Chief Justice Marshall's opinion in Worcester versus Georgia was one of the clearest statements of indigenous sovereignty in American legal history. The Cherokee Nation was a distinct political community. Its territory was not subject to Georgia law. Federal treaties with the Cherokee were the supreme law of the land. The ruling was issued. Worcester was eventually released, and the removal proceeded as though the ruling had never been written. Jackson did not formally defy the court. He simply declined to enforce its decision. The distinction, in practical terms, was meaningless. When a small, unauthorized faction of Cherokee citizens signed the Treaty of New Echota in 1835, ceding all Cherokee land without the authority of the nation's government, John Ross presented Congress with a petition bearing over 15,000 signatures in opposition. Congress ratified the unauthorized treaty regardless. What Worcester versus Georgia revealed was not that the law was unclear. It revealed that the law, however clear, operates only as far as those with power choose to carry it. The ruling existed. The enforcement did not follow. The distance between those two facts is where history lives. The Cherokee homelands were distributed to white Georgia settlers through a state lottery. The process was orderly. It was documented. It was administered through the normal channels of government. What it accomplished, the transfer of a sovereign nation's territory, was achieved not through conquest alone, but through paperwork. In 1838, 6 years after the Supreme Court ruled in their favor, the United States Army forcibly removed the Cherokee people from their homelands. Approximately 16,000 people were marched westward under military guard. Estimates of those who died along the route range from 4,000 to as many as 8,000, from cold, hunger, disease, and exhaustion. The Cherokee called it Nuna Dadal Tsuni, the trail where they cried. The Cherokee Phoenix printing press was seized and destroyed by Georgia authorities in 1835. The newspaper that had published the nation's legal arguments, political debates, and cultural life was silenced, not as an afterthought of removal, but as a precondition of it. Silence the voice, then move the people. New Echota, the capital of a constitutional republic recognized as sovereign by the Supreme Court of the United States, was abandoned under military compulsion and its territory incorporated into the state of Georgia. The buildings came down. The land was surveyed into new ownership. The administration of erasure was thorough. The removal was documented in extraordinary detail. Names, ages, health conditions, deaths recorded in federal ledgers with the same administrative calm used to record the distribution of rations and the inventory of supplies. The bureaucracy that could not be mobilized to enforce a Supreme Court ruling was fully mobilized to record the consequences of ignoring it. Every step was legal within the system that carried it out. The Removal Act was law. The land lottery was law. The ratification of the unauthorized treaty was law. What was not law, what the Supreme Court had explicitly ruled unlawful, was the removal itself. That distinction was administered away. What was lost was not only land, it was the specific relationship between a people and a particular landscape, the accumulated knowledge of those river systems, those growing seasons, those medicinal plants, those burial grounds, those ceremonial sites. Knowledge that cannot be relocated because it belongs to a place. A group of Cherokee people, led by a man named Charlie, resisted removal by disappearing into the mountains of western North Carolina. Their resistance, and eventually a negotiated agreement, allowed a portion of the Cherokee population to remain on their ancestral land. Their descendants became the Eastern Band of Cherokee Indians. Their territory, the Qualla boundary, still exists today within the borders of North Carolina, a sovereign nation on land the removal was supposed to empty. The removal did not complete what it intended to complete. The Cherokee syllabary survived the Trail of Tears. The language survived. Suppressed in boarding schools, pressed underground during assimilation campaigns, it was carried forward in families and communities on both sides of the removal, in Oklahoma and in the North Carolina mountains. It is spoken and taught today. Worcester versus Georgia never disappeared from American law. It survived as precedent. cited in tribal sovereignty cases across the 20th and 21st centuries, its core principle that indigenous nations are distinct political communities with sovereign authority over their territories is never formally overturned, and its implications are still being argued in federal courts today. The Cherokee Nation today serves over 400,000 citizens with its own governmental infrastructure, healthcare system, educational institutions, and economic enterprises. The Eastern Band of Cherokee Indians governs its territory in North Carolina, 2 nations, both surviving, neither finished. The tension Worcester versus Georgia named has never been resolved. The question of whether indigenous sovereignty is real, whether it has practical force or only theoretical existence, is still being litigated, still being contested, still being answered differently by different courts in different years. Worcester versus Georgia remains on the books. It has never been overturned. Its principle that indigenous nations are distinct political communities with sovereign authority over their territories is still American law. What changes from era to era is the willingness to act on what the law says. This is not a finished story. It is an ongoing negotiation between 2 understandings of sovereignty, one that treats indigenous governance as a historical artifact to be managed, and one that treats it as a living political reality to be respected. The Supreme Court in 1832 sided with the latter. The question of who sides with it today is asked anew in every generation. Return to those marble steps, to those words, equal justice under law. In 1832, the law was clear. The Supreme Court had spoken. The Cherokee Nation was sovereign. The ruling existed. It was simply not enforced, because the people with the power to enforce it chose not to. This was not a failure of the legal system finding its limits. It was a demonstration of what the legal system was actually for, and who it was designed to protect when protection became inconvenient. Worcester v. Georgia did not fail because the law was unclear. It failed because the law was clear, and power looked at that clarity and chose something else. The Cherokee are still here. The ruling is still on the books. The mountains hold what the textbooks quietly moved past. That choice to move past, to compress, to call tragedy what was also defiance and what was also crime, is itself a kind of answer to the question Worcester v. Georgia asked. We are still deciding whether to give a different one. This is before America. For those who believe that the history we were not taught is not behind us, it is the ground beneath us. The law that was ignored is still law. The nation that was supposed to disappear did not disappear. Stay with us. There is much more to learn.